Well, welcome everyone to today's Silicon Valley Forum Fireside Chat. The topic is startup legal challenges, and we'll be spending the next hour with Matthew Lopez. Matt is the managing partner with Wolf and Snow. And before we get into the conversation, we've got our customary introductory messages. First, the Silicon Valley Forum. We are a California-based 501c3 nonprofit organization. Our mission is to foster innovation, entrepreneurship, and leadership in Silicon Valley and throughout the world. We achieve our mission through events, programs, and conferences where the Silicon Valley Forum functions as a center of knowledge and connections, covering everything from the latest tech trends to the startup and investment ecosystem. And our activities are aimed to educate, train, inspire, and connect technologists, entrepreneurs, corporates, and investors. We've got a couple of events coming up. One in the Bay Area is on May 17th is the National River Day Cleanup in San Jose, California. We'll be meeting at the very south tip of the San Francisco Bay. This is the annual National River Day. And our next fireside chat is going to be on autonomous AI agents to detect gun violence before it starts. And this is with a company called GunSense. And we'll have a couple of their co-founders as guests on May 28th. You can find this information on our website, siliconvalley.forum. The disclaimer, we got a lawyer here who is not our counsel, but he'll appreciate this as an attorney. The Silicon Valley Forum, a California Public Benefit Corporation, SVF, does not endorse or sponsor any commercial product, service, or activity. SVF's production of this event does not constitute endorsement by SVF or its representatives. All SVF's programs and services are extended to the public on a non-discriminatory basis. We are a 501c3, publicly supported nonprofit. We thank you for your support, and I do want to acknowledge the following corporate sponsors for their ongoing support of the Silicon Valley Forum Fireside Chat Series: Blocks, Forensic Financial Services, and Global Tactics. All right, we will get out of the stop sharing and get into the conversation with Matt Lopez. Matt, thank you very much. And for joining us and to really get down into it. First question I want to pose to you is that what is the question you think startup founders should be asking that they don't ask?
I think the biggest thing that startup founders mess up with is employment law. I think that's the easiest thing that most founders will mess up. They hire people, they just start working with them, and they're not A, protecting their IP, or B, protecting employment laws, like the violations when it comes to that. And so I think that's one of those things where they need to ask the right questions about how to structure that to be able to make sure that they're doing all of that the right way.
So when it comes to employment law, when I think of employment law, I think about employee contracts. How soon, let's say a company incorporates, and we'll get into the articles of incorporation or article, for a corp or certificate formation for LLC, but in a little bit. But once they have the business going, is it your recommendation that the founders have their own contract with the company, or how soon when they bring in the initial employees of the team, should they have the employment agreement?
So most early stage companies can't afford the consequences of hiring employees. So a lot of the times what they'll do is they'll misclassify employees as independent contractors and to get by with their situation. And it's better than most situations, but it still just leaves you open for for misclassification lawsuit on that. The better way to do that is the traditional Delaware corporation structure. What we recommend for a lot of our clients that are going to be not raising enough money to deal with employment laws is your Delaware C corporation and then a Delaware LLC. and then having everyone at the Delaware LLC level, because if you are a member of an LLC, you can't be an employee, and therefore employment laws don't apply. And then
go
all
ahead,
you
Matt.
do is then what you do is you put in place a trigger event where you can have those LLC members exchange their LLC membership units for shares in the parent corporation at a certain point when the company has enough money to be able to have employees and do the setup and pay all the taxes and do all of that stuff.
So you mentioned, before I go to a following question on that, you mentioned Delaware. Delaware has it's been in the news a couple of months ago, they've changed their laws. I'm seeing more companies incorporate in Nevada. Is Delaware still the jurisdiction to be in? How does Nevada compare to that? It seems like if you're in blockchain and some of that, Wyoming is a popular place. But so there's two questions. There's the jurisdiction, but if you're operating in California, you still need to file as a foreign corp with the Secretary of State in California and be subject to the franchise tax. Is that correct?
If you're doing business, and each state's got a different definition of doing business. And so it's a determination on a state by state issue of whether you need to file a foreign corp in that state. So that's how you have to deal with that. A lot of the times, if you're not making money, you don't have any employees, you're not doing business in that state. If you have an LLC member and there's no money being passed through to them, you might not be doing business in that state. So a lot of the times the doing business only really triggers when there's an event-based thing. And usually that's money or employees, and every state's different regarding this. Back to your original question about Delaware versus other states, Delaware is still the standard. That is still a shifting landscape, though. We are starting to get more and more companies asking about this and making decisions to not go to Delaware because there are other states that have created similar regulatory schemes to Delaware that investors are getting more and more comfortable with. And that's really what it comes down to, is that regulatory scheme and investors becoming comfortable with it. Because the reality is, I tell this to my clients all the time, your job is to get an investor to say yes to you. The reality is, investors are looking for reasons to say no to you. And any reason that is away from their little cookie cutter check boxes makes it harder to get that money. And so most investors are comfortable with Delaware. If you are something else, that means that you have to explain why you picked that and get them comfortable with it, which makes for more friction in the transaction for being able to get investment dollars in the door. The other major thing is that a lot of states, they provide better taxation or better other issues other than Delaware. A lot of that only comes into play once you're generating revenue. So my advice to most startups is, once you're generating profits, then it's worth taking a note on where you want to be headquartered, where you want to be domiciled, and being able to make that transition. At an early stage, your job is to generate revenue and get investment dollars in the door for early stage companies. What is the easiest way to do that? And most of the time I advise my clients, do Delaware because it's easier. No one's going to question you if you're Delaware. Don't worry about making money or paying taxes, because that's a successful man's problem, not a startup's problem. So worry about the issues in front of you, not the things that are coming 20 steps down the line. Let's focus on, maybe getting through Series A or Series B financing. And then you can worry about a tax issue of, hey, we're so successful, we have millions or billions of dollars in revenue. How are we dealing with our taxation issue on this?
When I incorporated my first business, it was May trying to remember the exact date, but I had it May of 1993. So 32 years ago in Colorado. Um, and I think this was before most states were even allowed to have an LLC. I don't think the
LLC
LLC.
LLCs are a very new thing in the last like 20 plus years. It's
Yeah.
not, and it's slowly trickled into becoming more and more normalized.
So, I mean, and I'm sure people can, go, there's plenty of resources on knowing the difference between a corp and an LLC. I know as an investor, I don't invest in LLCs. I only invest in C corps. And of course, you got C corp and S corp, which is an IRS designation. And, even LLC can be taxed as an S corp. My consulting company is an LLC, which is taxed as an S corp. But I am kind of curious, again, at the higher level, is what are kind of the advice of why one should consider an LLC versus a corp, C corp or S corp.
So I'm not suggesting that startups become LLCs. What I'm suggesting is they set up a subsidiary
Right.
of the corporation to house the workers and the IP originally. And then at some point, they can close that down and move it up because of employment law reasons. But when you're talking about the difference between corporations and LLCs, it really comes down to one thing, and that's whether or not it's called a pass-through entity. So LLCs and S corps are what we call pass-through entities, which means that all of the profits, all of the losses pass directly on to the shareholders or the owners of the entities. And investors like yourself don't want the taxation to directly come and hit them every year. If you invest in 10 companies each year, you get 10K1s each year for each one of those companies. And that starts messing with your taxes and creating a whole slew of complications. That's why investors don't like pass-through entities, because they don't want some company that they invested in screwing up their taxes. That's why they like corporations, because then they only get dividends. Dividends are a very easy thing to deal with. Or if the company sells, it's a one-time transaction, and it's much easier from a tax perspective to deal with that than to deal with, a bunch of K1s coming through your door every tax season. So that's why investors will never touch an LLC. LLCs are really great for, smaller companies like my law firm. My law firm has to be a corporation because of California, but we're taxed as an S corp because I want the pass-through pieces of it. Whereas if you're going to take investors, you have to be a corporation, and you don't want to be an S corp because, again, investors won't touch it.
Yeah, I have found my experience at S corps, you're also limited to the number of investors. The last time, I mean, I know it's been, I think the limit's over 100. When I last looked at it many years ago, I think it was a cap is 75. And also, you cannot have international, non-US citizen investors.
Yeah,
And I don't think
there's a lot more
yeah,
complications with that, but at the end of the day, you don't usually go that far down the rabbit hole, because you just tell, or at least I tell my potential clients, don't do that. You're going to cause so many other issues for it.
and of course, very few companies, do an IPO, but a S corp, or an LLC. Of course, an LLC can't do it, and S corp can't do it. So you already limited, again, from the investor. You're looking at exit risk. You've already eliminated the public offering option as an S corp. Going back to the employment relations. I meet a lot of companies, startups that, of course, and you just noted a few minutes ago that, most startups can't pay employees. So they're giving stocks, they're stock options or stock grants up front. What are some of the, common mistakes in that process that companies do when they go down that path?
It's what type of stock are you giving to employees at early stage? So there's three major types that you're going to deal with as a early stage company, and that's restricted stock, NSOs, and ISOs. So restricted stock is what you usually do as your first, like to your initial people, and that's where you buy it outright, and then it's kind of a reverse vesting. If you don't meet the vesting schedule, the company can buy it back from you at the original price. Versus NSOs and ISOs, where you're vesting and it's an option, and then you have to exercise that option down the road. And there's different tax benefits to NSOs versus ISOs, and I'm not going to get into the tax benefits on those, but it pretty much goes, you start with restricted stock, then you do NSOs, and then you do ISOs with it. And so what you're doing is you're making sure you do it the right way. You're making sure that you collect the money from the people that you gave the shares to. You make sure it's all documented. You make sure that you have the right vesting schedule in place on it. Like there's a lot of little details that go into making sure you give options or giving shares to members, and that you're documenting it in board resolutions and not just giving it away. Thankfully, there's a lot of tools out there for early stage founders to do this, hopefully successfully. Clerky does a pretty decent job of this. There's still issues with it. Then there's also the voting versus non-voting shares. There is the strike price, making sure you have a 409A at certain points, and when you feel like you need that. The government, unfortunately, has not really designed a lot of programs for early stage startups to really be able to do this. And it's very annoying because the government's like, yes, businesses should be this, and startups are this kind of early stage because you're a business, but you're not making money usually right off the gate. Or if you're making money, you're really not making profits. It takes a long time to scale up to that. And the system isn't built for that, unfortunately. And so you have to know the right workarounds to get through all of those issues successfully, without really causing too much damage to the company. And that's usually what ends up happening is you kind of just fumble your way through to your Series A. And if you make it to your Series A successfully, then you hire attorneys to go clean it all up. And it's a big pain in the ass to do. Like, I personally hate it. And that's why I stopped working with really mostly Series A companies and worked more with seed stage companies, because I could build out that foundation and make sure they weren't doing anything stupid too early on, and I could fix all of it before it got to their Series A or post Series A, when they've actually taken investment money from investors. And investors are getting more and more critical and doing more and more diligence and are asking for more and more stuff from startups to make sure that they're, de-risking the ventures.
So I asked I had a colleague of mine over maybe 15 years ago. I say, when do you hire a marketing expert, or when do you? And the idea is that if you once you start spending $10,000 in marketing, you need to have someone doing that. I'd like to kind of pose that question to you. I mean, having been working with lawyers throughout my career, right, it's always best to have a lawyer from the get-go, from the beginning. But unless you've got the fees to do that, and I do want to give you an opportunity to talk about how your firm, Wolf and Snow, has a different model in working with startups. But when should a founder or the founders consult the guidance and expertise of an attorney?
As soon as they can afford it. Like, the reality is, just like there's tech debt of you're building something and it might not be the right way, there's legal debt. And every time you do a transaction, every time you do something, you're creating legal debt and you're creating risk, you're creating all sorts of stuff. So the reality is, you're trying to de-risk a venture. You're trying to build out all of your different pieces to make sure that everything's in good shape. And the reality is, attorneys set a lot of that foundation from your go-to-market, your partnerships, how you're selling the products, privacy, to hiring people, to corporate governance. There's a lot of stuff. Like I go into a lot of companies, even earlier stage companies that are looking to get ready for their Series A, and the cleanup that you have to do is massive, even like to get them back into shape. And so the earlier you can get someone in to make sure that you have the right structure and the right systems in place, the better off you're going to be, because it's way cheaper to do it the right way or than it is to go back and have to clean it up.
So tell me more about the firm you're operating in, because you do have a unique business model and how you work with startups, where you kind of, the fractional general counsel, and tell us more about your firm and the uniqueness of the way you work with startups.
Yeah, so I'm a what you call a fractional. I'm a general counsel, and I run one of the first fractional legal departments in the United States. And so what we do is we realize that early stage startups can't afford us. And so what we do is we defer a lot of our costs till Series A, and we end up taking an equity stake in our clients. So very much I act like a venture capitalist. I'm very picky about my clients. We really only take maybe one client a month. At that, we're usually looking for an average about 10 clients per year to come on new, because we're generally working with our clients for 2 to 4 years, depending on the life cycle of where they are and where they need to get to. And we usually stay with them for a fairly long amount of time, running their legal department, making sure that they're doing everything right until they get to a place where it makes more economic sense for them to hire a full-time attorney in-house. And so we're usually that stopgap. We are not a replacement for big law. You still need a big law firm because there's certain things that they are really good at that you need help with, such as your Series A financings, any type of niche compliance issues, and even what I do, I work with outside counsel all the time. One of my clients was doing a acquisition in Canada, and my job is to quarterback all of that, work with all the outside counsels, tax counsel, all of this to be able to get the deal done for them. And so my job isn't to know everything. My job is to know enough to be able to talk competently to all of the other people to be able to bring something together and get it done correctly. So my suggestion to a lot of early stage founders is you don't need to have full-time people. You need to have competent, good fractionals in those high level positions, because the reality is you're not going to be able to afford most of those people, like real rock stars, heavy hitters. But you can get a piece of their time and make sure that stuff's going the correct way. And so that's where I like to advise a lot of my clients, like, you don't need a full-time CMO. You need a part-time CMO, fractional, to be able to help you with your stuff. You don't need a full-time CRO either. You need maybe a full-time salesperson, but you don't need a rock star CRO to be there full-time. You just don't have the bandwidth or the capacity to be able to pay that person. And their skills are meant for managing and building process versus, doing the grind and calling everyone or working deals and doing all of that stuff. So making sure you have the right tools and the right percentage of that time at the end of the day.
Yeah, I live in a world, I'm not a technologist, so I understand the business of technology, and I understand particularly the sales, marketing, and finances. And my adage is, if you don't know your numbers, you don't know your business. And I'm routinely surprised on, you don't need a full-time CFO, but you need someone pretty early on to make sure your business development, your tech product development is also aligned with your financial development. And most startup founders who are smarter than I am on the tech side, but really don't understand the financial implications. So before we get into kind of your background, because I'd love to hear, I think there's value to understanding more about how you got in this field and whatnot. early on when a business is formed with the formation, the articles of incorporation, how quickly are you seeing mistakes made just within the formation documents, whether it's the articles, the EIN, maybe even a shareholders agreement between the partners, the founders. How quickly are mistakes made, and what are a couple things that you think founders should be aware of?
It really depends on how they got those documents or who they're working with for it. If they're doing it themselves, they probably made some type of mistake. If they went through something like Clerky, then the chances of them messing it up are lower. Um, like usually we don't see issues with the actual formation of the company. Like that's pretty rare. Like you either did it or you didn't. Like there's no gray area with that. Then it comes down to making sure you get all the board resolutions to give the powers and all of that stuff. You got the shares, did all of that. And that's where stuff can get tricky. And each attorney has their own checklist of what they think needs to be in there. There is certainly a like core group of like, these are things that need to be done for board resolutions. And then there's preferences that other attorneys have. Like, I'm not a big fan of shareholder agreements. It's not I don't do them for my clients. I don't believe in them. I think those should be in the bylaws. If there's something that important, it should apply to everyone, not just the founding group. And you're also creating more paperwork, in my opinion, versus just, here's the standard bylaws. Let's put these together and let's move on. Because the reality is, none of this really matters unless you get traction and you get off the ground. And Series A financing is going to require a lot of, they're going to overhaul your bylaws. They're going to overhaul a lot of stuff for you. So I don't try and put a lot of effort into the formation stuff, because that's not where a lot of that's going to change at the end of the day, in my opinion. And so as long as they have the basic easy stuff, it's probably going to be better for them in the long run than trying to over complicate it and trying to I've talked to founders that are like, oh, I want to do what Uber did, or I want to do what this company did. I'm like, yeah, the thing is, VCs have gotten smart about this stuff, and they're not playing these games anymore. Like, they want it bare bones, easy. And if you want to play those games, I'm not the attorney for you, because I don't want to, it's just going to create a bunch of work for me. I'm going to then have to and then it's going to lead to problems at your financing. And I don't want that. I don't want to deal with that headache at that point. And so I'm able to talk a lot of clients out of those issues and just keep it simple when it comes to that. It's usually after that is where problems start happening.
Interesting. So tell us about your background. Where did you grow up? At what point, did you consider becoming an attorney? Let's start with that.
Yeah, so I'm originally from the Bay Area. I'm from Concord, Walnut Creek. Went to Cal Poly, got my master's in history. And then from there, I went actually into teaching, because I graduated in 3 years from Cal Poly. And so I wasn't ready to commit to law school at 21. It was a huge financial commitment, long term, 3 years. So I was like, I was either going to be a teacher or a lawyer. So I went and did the teaching stuff first, realized that the teaching system was totally broken, and was like, I'll just be collecting a paycheck in 5 years. And I didn't want to do that to my life. So I went to law school. While I was in law school, I ended up starting a tech startup. Got raised $250,000, burned through it, made some critical issues. Didn't have the experience to be able to solve them. I've always had a very entrepreneurial background. I ran multiple businesses during college, post college, everything you can name. And so at that point in law school, once my startup failed, I realized, you know what, it's better to be working for startups than to be the founder. I'd rather enjoy the sushi life rather than the ramen life. So I started working for startups as in-house counsel, worked my way up to being a general counsel. And at that point, I was working for a company, and I was dealing more with VCs and seeing what they were doing. And I realized they had a very good model. And I'm stuck here working at one company. I've got all of my eggs in one basket. And if that basket goes belly up, I'm out. Like I get nothing out of it. And so at that point, once that company went belly up, I decided to become a fractional. And so I knew about fractional CFOs, and I kind of modeled my business off of that, VCs, and started working toward like tweaking my model to find to what it is today. And right now, for the last, I'd say probably two years, we found like the pattern that works, the systems and everything. And we've been very successful since we kind of dialed it in. The first 3 years were a lot of figuring stuff out. But now we've got really great clients. We've got really great processes and systems, and we know what we're doing when it comes to finding clients, working with them, and being able to execute successfully for them. And so it really came down to like innovating and finding something new and finding a gap in the market, because you have big law firms and you have in-house, and there's this gap in between. And early stage companies can't afford big law because it's so expensive, but that's really their only option. And they're not big enough to hire someone full time. And so that's where I kind of try to put my business model as a fractional legal department in there to kind of span that gap for companies. So that way they can get access to good legal without it costing them an arm and a leg. Because the reality is they need to put their money into development, into growing the business at that early stage. They don't have resources for legal or accounting. They need to find more creative ways to be able to do that, to be able to get those services and be able to get to that next stage where they can't afford them. And so that's where I created my model of deferring a lot of my costs and taking an equity stake, because I want to be like VCs they help keep startups going. And startups need a lot of help at that early stage because it costs a lot of money to get a business off the ground, especially a tech company. It's getting cheaper and cheaper as technology is getting better and better for companies to be able to build that stuff. But labor is still expensive. Like, just like you have to do sweat equity as a coder and stuff. Like, same thing with other positions. You need to find those people that are willing to believe in your vision and be able to take you to that next level.
So what did you teach?
I taught history and government.
Okay. At what level?
High school.
At high school. Okay. And the public school system?
Yeah.
Okay.
Yeah.
And so, and then when you went to law school, I'm, don't, as a good lawyer would say, assume makes an ass out of you and me. But did you read Scott Turow's book, 1L? And is that even recognized anymore? That shows how old I am.
I never read that book. I read Planet Law School, and that dictated how I did law school, and it made my life a million times easier. So if there's any people that are thinking about being attorneys, that is the book to read, because law school is a game. And if you know you walk into it and no one tells you the rules, but Planet Law School told me the rules, and I worked pretty much 30 plus hours a week and to 40 hours a week and went to law school at the same time. And that's not recommended. And I was able to successfully get it done because I knew exactly where to spend my time to get it done. I knew exactly how to get good enough grades to keep going through the program. And I passed the California bar on the first try because I knew exactly how I could get enough points to get over that threshold. It's not about knowing everything. It's about knowing you as an individual and how to get through the game. And there's 3 different things. There's how to do law school, how to pass the bar exam, and then lastly, how to be a good attorney. Those are 3 different skill sets that are not necessarily related to each other. And so I was very thankful that I did speech and debate all through high school and college. I had a very good work ethic. So it wasn't difficult for me, but it's all about making sure you understand the rules. Just like with startups, if you know the rules, you know how the game is played. Like, what do investors looking for? What are customers? What are partners? If you know how, what it takes to get those things done, they're the same across the board. Investors want to make money. How do you show that investor's going to make a bunch of money with you? How do you de-risk it for them? Like, these aren't hard questions, but it's how do you apply your situation to an investor? How do you make them feel warm and cozy giving you money? And it's all about relationships. People invest in people they trust. If they don't know you, they don't trust you, they're not going to give you your money. So it's all about those little things. If you know all the rules, you know how things work, everything becomes a lot easier.
Very true. Let's talk about AI. We can't have a conversation in this day and age without talking about AI. I am kind of curious on hearing your perspective. How is AI changing your field, the legal field? It wasn't that long ago you had the researchers and the paralegals and going through Westlaw, Westlaw and LexisNexis, and maybe those companies are out of business these days. That shows my age, but now AI is changing the research side, as I understand it. The preparing, if there's litigation, the preparing of pleadings. But from your perspective, how is AI changing the legal field?
It depends on it. I would say it's changing different sectors of the legal field more than others. So litigation has gotten hit very hard with AI because there's a lot more research, preparation, all this stuff that goes into it. So anytime there's a time suck, AI can be used to help as a tool to help that process. Whereas other fields, it's not changing as much because, like, at least for me, like, I don't use any AI. I actually don't trust any AIs to help me with my stuff because it's going to be more problematic than it's worth at this stage because of where I'm at. I spent a lot of money, a lot of time building out processes and systems to be able to speed up the stuff that I do. And I've trained my paralegals to do those tasks extremely efficiently. Whereas there's other things where, like litigation, doing all that research, that's a crapshoot. And AI is way better at reading and digesting a bunch of stuff and spitting out an answer than a human. Whereas reading a contract, I don't know any AIs that can successfully read a contract and nab all of the issues that is pertinent to my client in that situation. Because the issue is the parameters in which I view a contract or read a contract are because I know my client so well. And the reality is the inputs that you would have to put in to make sure that you're digesting and doing it right take a lot of effort to train a model to be able to pull those things and do those things in an accurate way. So I'm not saying that it's not going to happen. I'm just saying I don't think AI is more of a tool for certain particular tasks, automating things. Like, there's a lot of new AI, and I keep my pulse on this for contracts. And that's going to be a big area where AI is presented in my world. But for, immigration, for probate, for litigation, there's a lot of overhaul in those areas because it's speeding up a lot of the processes. And I always tell people that are doing AI, build tools for humans. Don't try and build solutions where a human isn't in the loop. We're not at that stage yet. We don't have good enough AI. We haven't cracked that code yet. And so unless you're a research institute like you're at OpenAI or one of the big ones, yeah, they're trying to crack those things. But if you're a small time startup, unless you have something super revolutionary, build a tool for someone, because that's how you're going to get a human to buy it. Why would I buy a tool that hurts my business? And so that's where you have to get into places. How do I speed up doing a process and being able to make sure that the other person is still making enough money to live?
talk about the current geopolitical situation. What are some of the issues are you following more closely these days on how it might impact your clients?
I think it really comes down to the tariffs are a big issue and it's a big unknown. And because of that, we're currently in the worst um, investment time that I've ever seen. Like, COVID was bad, and then it got really good because people had a lot of money to spend that they had, and they had to invest in companies, and it was it was like booming, and then it's just gone downhill from there. And investors have gotten more and more critical of businesses and slower to invest money. Right now, like the original, like when I started out, it was like 3 months. If you started like looking for funding, 3 months to 4 months, you could probably close the round or close your money. Now then it moved to 6 months. Most experts are now saying you need to start 12 months before to be able to close funding. So it's the landscape for investing has changed massively. And that means that more and more companies need to bootstrap longer to get to revenue because most investors want to see some type of traction these days. And it's really hard to get good angels. And VCs are a lot of people that I know are complaining that VCs are not, they need to take the word venture out of their name because they're not venturing anything. They're looking for sure bets. And so the market's really changed when it comes to that. But those are the impacts of a shaking market. We don't know where it's going. So people don't want to put money in because they'd rather stay liquid until they know which direction we're going at this point. So that's the big impact that I see on the startup world.
Are you seeing less, I live in the world of international business. So I guess my question, are you seeing obviously less international transactions? You mentioned Canada, but, what I've always said, companies, when I started my career 30 plus years ago, if you're a US company, you conquer the US market first and then expand internationally. I've started kind of preaching, 10, even 15 years ago, that companies can start looking at high growth international markets first. Even China at the time, which was growing like crazy despite the risk, it was just too big of a market to ignore. Now kind of seeing that with India, Southeast Asia, even Africa, which is a billion person market. So, what is international business and how is it changing and from your perspective and advice that you're giving, not just for the next 2 or 3 years, but even 4, 5, 6+ years down the road?
So it really comes down, it's company by company situation, I would want to say, because the advice you give to like B2C company versus a B2B company changes dramatically. And what is your target like market for expenses? A lot of the companies I work with are fairly expensive products. So going to India or Southeast Asia or any of that, it's just not in the cards. Those aren't the ideal customers. They're not going to get the revenue out of that, the extraction. It's better to stay in the US. So a lot of my clients are still very US focused, conquer the US market, and then expand from there. Or go to Europe and US, tackling those together. And the problem is a lot of the times when you start talking about Europe, you have a whole slew of new compliance issues that aren't in the US. And so it's, have you spent the time and the money to be able to make sure that your product, your service is compliant over there? And that it really is a case by case basis on whether or not they can tackle that market and whether or not they even have contacts in that market. Because the reality is most early stage companies, they need to get traction. And most companies have not successfully created that kind of flywheel of, if we do X, we're going to close a customer. Or like if we do this 5 times, we close 3 out of 5 customers. They're still trying to figure that out during that. That's really what Series A is for a lot of companies. After Series B, they should have that documented, and it should be a turn and burn at that point. And that's where, in my opinion, you should be thinking about international. But until you're able to actually have a successful process to close business, trying to tackle something outside of your comfort zone is dumb, in my opinion. Like, unless, like, again, there's always different circumstances for different things. Like, the types of clients I take are very much B2B clients, because there's more value I can add at that level than B2C. Like, if you're selling a bunch of widgets to a bunch of consumers, like, I'm not as useful. Like, I'm not there's not a bunch of contracts that need to be reviewed. There's not, like, maybe there's a bunch of partnerships or distribution agreements or something like that add value to a company. But most of my clients are B2B. They're big products. They're heavy contracts that you're dealing with that kind of stuff.
Are you finding, or do you handle companies? You mentioned Europe. There's been a trend for many years, even a couple of decades, of European companies setting up operations into the U.S. market. The attraction of the U.S. market is much less regulation. So the cost of doing business is less. But do you work with European companies expanding to the U.S., and what have you seen since January 20th, that trend?
So I've worked with several companies that have flipped into the United States, and a lot of the reasons why they do that is, one, the investment dollars here in the US. Like, the investment dollars in Europe is very different than the investment dollars here in the US. And what the Europeans take as risk level, and how much money they put in, what criteria they have, it's very different. And so a lot of early stage companies need to get out of the EU market and get into the US market to be able to make it because of that. I don't see a big enough span of these companies to be able to make a good judgment of what's happened. But the conversations that I have had, I've warned companies coming into the US market lately about this and saying, hey, maybe don't right now, because A, the investment dollars aren't flowing here, and B, like, who knows if you might even get kicked out of this country at this point. So there's a lot of money that goes into flipping into the United States, and it's not something you want to take lightly. And so I think my guess is that a lot of companies are going to stop doing that until we've settled a lot of issues here in the United States.
How far does when you have the crystal ball? So I'm going to reframe the question I asked previously. How far advance are you giving advice? Are you trying to lead your clients as far as time? 2 years, 3 years? Is it now just by the the election terms? How far? Certainly, when I started my career, you're kind of thinking 10 years out. I mean, that was the norm. I think it's now very difficult to be thinking 5 years. I get a sense that 3 years is kind of the timeline. But I mean, it's an arbitrary question in many ways, but part of the strategic planning and risk identification, risk mitigation. What's the timeline that are you advising your clients?
By financial rounds. How do we get from one financial round to the next one? That's as far as they need to look ahead, in my opinion. Anything past that is too difficult for an early stage company, and it's not worth planning for, because there's too many variables. If you are a fully fledged business like Fortune 500, yeah, you got to be thinking 10 years out. You got to be planning very far ahead. But a lot of these early stage companies, let's be real, they might not be around in 5 years, 3 years. They need to get from this is where we are to how do we get to cash flow positive or the next financial round. And I tell my clients, that you need to, when you take money, you need to have a plan for to use that money to get to cash flow positive now, because you don't know when your next investment round is going to be. You need to act more like a traditional business than the normal tech, where you used to be able to just keep raising until you got to profitability. I don't think that's the format. And AI, there's a lot of people that I know that are talking about, that are investors that are worrying about giving money to AI companies because they're afraid that they might not need another round after that. They might be able to use that money, get cash flow positive, and then never do a Series A. They might just do safe notes or convertible notes. And they might be stuck with those. So there's more and more talk about that. I'm hearing more and more about that, to be able to make sure that you're like, how much money do you actually need to get to cash flow or get your business off the ground? Because I know several of my clients, they might very well be able to do one financial round and be done. Like, because you don't need as many people these days to run a business.
Yeah, I don't know. I mean, you and I met at an event in San Francisco, and I don't know if I said it there, but I do say it on a regular basis. Again, when I started my career, to get that unicorn $1 billion valuation, you needed roughly $300 million of combination of revenue and money raised, and thousands of employees. I feel strongly that today you can do it with maybe 50 million and just a few hundred employees, because with AI, that the AI is bringing to the company. And so I completely agree with you on that. Let me ask you more specifically about intellectual property, IP, and some of the concerns there, just generally for a business. Now, in my world, IP is trifurcated between patents, trademarks, and copyrights. I find a lot of startup founders don't really understand that, and I've always said, go to uspto.gov and just very quickly, you don't just learn the very basics of that, and I'm kind of surprised. But from your perspective as an attorney, what is it that, going back to my first question, what is it that you think founders misunderstand about IP protection? And in the same thing, how is AI changing either the copyrights issues? I've got a friend of mine that's an active blogger, well named, and his work, which is copyrighted, is coming up in some of these AI algorithms and these outputs. And I know there's lawsuits involved with the New York Times, and other media outlets are suing some of the big tech companies. So it's kind of a larger questions in there, but I'll throw that out to you generally. Take any aspect of that.
So the major thing that most founders mess up on is trade secrets. So the USPTO manages several pieces of IP. It does not manage trade secrets. And trade secrets are the lifeblood of most tech companies because they don't have the ability to patent everything. And so, what is your secret sauce? That's a trade secret. And you have to be able to understand what a trade secret is, what protections you need to be putting in place to be able to protect that so it maintains its status as a trade secret and becomes an asset for your company that someone else can't go and take from your company. So I think that's the thing that most people mess up on, is that aspect, and not understanding what is a trade secret and being able to document it properly. It's hugely undervalued asset in companies that no one's really talking about or dealing with or anything. And so I think a lot of companies have a lot of IP in their company and they don't even know it. One of my clients, Big Idea, shout out to them, is working on this problem. And if you have they have amazing technology when it comes to being able to identify these things, being able to identify them, and even do competitive analysis and evaluations on your IP. They're going to crush it. But it's one of those things. Most companies don't even know what IP is or how to protect it or what to do. They know patents. They're like, oh, we need to patent this. And it's like, no, because if you patent this, you're going to tell everyone how you did it, and they're just going to figure out a way to get around your patent. Trade secrets, on the other hand, you keep it secret and no one knows how you're doing it. And you get that asset. So it's a really important thing to understand those things. Going on, jumping to the other issue that you're talking about, which is AI and IP. That's a huge issue that's going to take the next couple of years to figure out. And I hope lawmakers start actually dealing with this issue, because the USPTO needs to actually understand how they're dealing with it, because AI is just gobbling everything up and abusing a lot of IP rights. And it'll eventually come to a head at some point. But I don't have a crystal ball on how they're going to do that or when that's going to happen. But it is a huge issue for companies, making sure that you own your IP and you own all of your stuff. And the third thing that I would want founders to be very aware of is making sure that you don't put your code into like an AI generator. You might not own that code then. And that's a huge issue that's going to be coming to a head right now. Or putting confidential information into these AIs and then not owning it or exposing it, your confidentiality, you're breaching your confidentiality. Or you could be breaching agreements that are under NDA with other companies. So there's a lot of issues that are going to be coming up with AI and IP, and it will be interesting, to say the least.
We got a couple more minutes here. You just mentioned the three letters, NDA, non-disclosure agreements. When do you think is the appropriate use of an NDA? We're talking about like with the team, with the employees, maybe advisors. I know when a company comes to me and I'm a prospective investor and they give me an NDA, I get very reactive because you're saying, well, you want me to trust you with my money, but you don't trust me with your idea. I've always said, as an investor, I don't sign NDAs until we're doing the due diligence process. And it's like buying a car. All right, I'll look at the car,
Yeah.
but once we start taking apart the engine, looking at the agreements, looking at the secret sauce, looking at trade secrets, then we'll do NDA.
Yeah.
Feel free to comment on that, but really about because I do find that startups with their own team, and I do agree with you about trade secrets. I'm glad you mentioned that, but they're not doing enough. I think they're protecting within their own ecosystem with NDAs. So, what are some of the do's and don'ts with NDAs? That's the question.
So NDAs are for external people, not internal people. That's the first thing that needs to be very clear. NDAs are for people outside of the company that are potential you're going to have talks with. That's all it's for. Hey, we're going to have initial talks about something. We're going to talk about something. We haven't done a deal yet. That's what an NDA is for. Once you do the deal, there should be confidentially built into that deal that supersedes the NDA. The NDA is only there for our initial kind of getting to know each other. We can look under the hood of the car without having any issues. That's what it's for. Whereas employees, you need to have what's called a confidentiality agreement and work product assignment agreement, because you need to have confidentiality with them and you need to own all of the work product. And that's usually put together into one agreement, or is clauses in your offer letter or employment agreement. But my firm has separated that out from the actual agreement, from the whatever employment, IC agreement, whatever, to keep continuity with that agreement style. So that way, when investors do due diligence, you can point to that and say, hey, we have this same thing with ICs, with advisors, with employees, with everyone. And it's like 99.9% the same thing, minus a couple tweaks, depending on the relationship.
I appreciate that clarification. So one final question, kind of going back to this full circle. Um, what is it when you talk with prospective clients? What is kind of your not sales pitch, but you know, there's a lot of lawyers out there. What is it that's making you, Matt Lopez, different from in your firm, really different in value to your clients?
One, it's my expertise. So I'm not just a lawyer. I was an entrepreneur. I have a master's in accounting. So I can sit in a room of the CFO, the business people, listen to all of them, synthesize it, and give good advice on the situation. And a lot of the times, a lot of my clients, I'll solve a business problem for them. They'll talk to me about their business. I'll be like, hey, have you thought about this? Have you thought about that? They're like, no, I haven't. And that's why they like me, not because I'm a good attorney, but because I actually understand their business. And I know how to then be able to apply the law and make sure that they're doing their stuff correctly. And that's where I think a lot of attorneys are missing. They don't have the chops as a business person. You have to understand a business if you're going to represent them or protect them properly. It's not enough to just know the law and be like, oh, yeah, you have to do X, Y, and Z. Because most startups, they don't have the money to do it the right way. You got to come up with creative solutions to be able to get them from point A to point B. That's how I developed the Delaware C Corporation with a Delaware LLC structure underneath it, because my clients were violating a bunch of employment laws and I was tired of it. So I came up with a creative solution that didn't cost them a whole lot of money for it. So that's one aspect. The other one is the financial one. Most of my clients can't afford those big companies. We have a solution that fits that need. And a lot of people that push back against me are because they don't want to give equity. And I tell them kick rocks, because that's all you have. You don't have money. You don't have anything else. So if you're not willing to give equity to someone that's going to be able to help you, I'm not the right fit. I don't need to be the right fit for everyone. I'm more picky about my clients than you are about your attorney.
I very much respect that. I will say I've been blessed in my career to have some great legal counsel, and I think the common denominator is that they wanted. I think number one, they wanted me to succeed individually. They wanted the business to succeed, and but I also think it was maybe to my own horn. I'm a good client because I understand what my strengths and limitations are.
Yeah.
And so there's some things I'm able to do and do it very well. And particularly when I've ran my own startups, I know how to put the business plan together. I know international business, risk mitigation, but if the pie is 100%, I know that only 2%, and it does take the team, including a good legal team. So thank you, Matt. This was a great conversation, and yeah. So I'll put this up on YouTube. But thank you very much for your time.
Yeah. Happy to be here. It was a pleasure.
Talk again soon. Bye bye.